All right, ladies and gentlemen, good morning, everybody. What a great audience we have today. I think all year long, this one brings the biggest audience, in part because this is available for professional credit, for your ethics credit in CLE. All right, so to kick things off, for those of you who may not recognize me because I shaved off my beard, I am Michael Scharf, the co-dean of the law school, and I want to make a few announcements, tell you a little bit about what's going on at the school, and then turn it over to our wonderful speaker today. So the first announcement is that on Monday at 8:30 a.m., we have a wonderful speaker that we're co-hosting with the Cleveland Council on World Affairs. It's Philippe Francois Champagne, the Minister of International Trade of Canada, who is a 94 graduate of our law school. And he's in charge of the renegotiation of NAFTA, and he's going to tell us all about the prospects and challenges of that. That will be Monday at the Union Club, 8:30 a.m. There is a fee for that, and you can... 7:30 a.m. Thank you. Whatever it says in the advertisement is correct. And you can sign up online for that as well. This is the last of our breakfast meetings, but we will have another 6 starting next fall, and we hope that you'll all be coming to those. They have been a lot of fun, and we get a lot of positive responses from them. Just let me give you a quick update about how things are going at the law school and some other announcements. This year is another one of our big reunion years. It's the end of our 125th anniversary. And we're having an all-alumni dinner with all the faculty on the 12th of October, which is a Friday night. We hope you'll come to that. It's going to be at the 9 down in the vault, which looks like a big bank vault. It should be a lot of fun. The school has had a really good 125th year. We started it out by getting the results of the July bar, and for the first time in 30 years, we are number one in the state of Ohio with a 93% pass rate. And then in the February bar, the overall pass rate for Case Western was again number one in Ohio, and we did very well also with the few people who took the February bar and were first-time takers. In addition, our placements for our students are going up and up and up, and this is in part due to the improving legal economy, but it's really, really good news for the school. So for the last couple of years, we've had over 90% employed within 10 months of graduation, and that continues to be the case. This year, we have more people employed in law or JD required, bar required employment than we've had in a long time, and that's always good for us. Thirdly, because it's the 125th year, it's also the last year for our 10-year capital campaign. We're doing really, really well with fundraising, and that is a credit to our very generous alums. Our annual fund is running about 20% better than the past couple of years, which were all record-breaking years, so the alums are really giving. For our capital campaign, we had a $32 million goal. We blew by that a couple of years ago and increased it to $42 million. We are now at $46 million, and we're hoping to hit $50 million by the December deadline. Nearly all of that money goes to scholarships, and that has enabled us to bring in better and better classes and improve really the quality of our law school and who we're graduating. Some of that money has also gone to renovate various aspects of the law school, and I invite you, if you haven't been there for a while, to see our newly renovated moot court room, our new active learning classroom, our new telepresence room, and our new IP venture clinic, all of which has made the law school relevant and feel updated, even though we're not moving into a new building or anything like that. But we do want to thank all of you who have given to the annual fund. The deadline for this year is the end of the fiscal year, which is June 30th. That's coming up. The deadline for the capital campaign is December 30th. So, please help us again by continuing to share your generosity with the law school. Finally, and not least of the things I'm supposed to be doing today, is I'm very, very pleased to be able to introduce your speaker this morning. Professor Cassandra Robertson has been at the law school for a number of years. She's a chaired professor. She has the John Deaver Drinko BakerHostetler Professor of Law, which is a very prestigious chaired professorship. She has won our award for the Distinguished Scholar of the Year. She has won the awards for the Best Speaker of the Year. She is also the director of our Center for Professional Ethics, and she is a nationally known scholar and speaker. And today she's going to be talking about an issue which I think is going to captivate us for the next hour. So without further ado, please join me in welcoming Cassandra Robertson.
Great, thank you so much, Michael, and it's wonderful to be here this morning. Public faith in the impartiality of our courts is the bedrock of American democracy and the rule of law. In an increasingly partisan era, however, there's a growing skepticism of the judiciary's neutrality on politically charged issues. This skepticism creates difficulties when it comes to determining when judges should recuse themselves or be disqualified from politically sensitive cases. Judicial disqualification rules generally require a judge to step aside whenever a reasonable observer might question the judge's impartiality. But in an era where the public is becoming ever more politically polarized, how do we recognize the position of a reasonable observer? When is it reasonable to question a judge's impartiality? Two relatively recent cases highlight this dilemma from across the political spectrum. In the first case, federal judge Shira Scheindlin ruled that New York's stop and frisk policy was unconstitutional. This ruling was tremendously controversial, and it became a touch point in the New York and national political scene. Mayor Bloomberg was quoted as saying that he would feel, quote, responsible for a lot of people dying if his administration were forced to implement her ruling. After her decision was publicized in the newspapers, the Second Circuit stayed her ruling, disqualified her from the case, and criticized her actions. Interestingly, although the court stated that it was making no findings of misconduct, actual bias, or actual partiality on the part of Judge Scheindlin, there were three things that the judge had done that the court says gave rise to the appearance of partiality. First, in an earlier lawsuit, she had advised the plaintiffs that the relief they sought was not available under the settlement agreement that they had signed, and said that if they wanted the requested relief, they would need to file a separate lawsuit. Second, she participated in media interviews and profiles during this time, although interestingly, she did not speak about the pending case at all in these interviews. And third, she described herself to media outlets as a judge who, quote, is skeptical of law enforcement in contrast to certain of her colleagues, whom she characterizes as inclined to favor the government. These three things taken together, the court said, might lead a reasonable observer to question the judge's impartiality. After the Second Circuit's ruling, observers were very sharply split. Certainly the city's police commissioner agreed with the Second Circuit that there was an appearance of partiality in this case. The police commissioner was quoted as saying, "I have always been, and I certainly haven't been alone, concerned about the partiality of Judge Scheindlin." But others, including a number of legal ethics professors and retired federal judges, concluded that Scheindlin had done nothing wrong, and that no reasonable person could view her actions as giving rise to the appearance of partiality in the case. In fact, some concluded it was the judges on the Second Circuit who were perhaps influenced by an organized political backlash to Judge Scheindlin's ruling, who themselves displayed the appearance of bias. One law professor wrote that, quote, "The three judges not only permitted the norms of political discourse outside the courthouse to displace the conventional norms of the adversarial process and reasoned judicial decision-making, but also, ironically, failed to satisfy the very standards of judicial conduct to which they sought to hold Judge Scheindlin herself." A second case alleging judicial partisan bias arose last spring here in Ohio. A case pending before the Ohio Supreme Court challenged the constitutionality of Ohio regulations that required abortion clinics to have transfer agreements with a local hospital. The case was appealed out of Toledo, where the sole remaining abortion provider in Northwest Ohio had had trouble finding a local hospital willing to enter such an agreement. But the clinic was able to enter an admitting agreement with a hospital in Michigan, just across the border, approximately 50 miles away. When the case got to the Ohio Supreme Court, pro-choice groups called for Ohio Supreme Court Justice Sharon Kennedy to recuse herself. She had recently spoken to a Toledo Right to Life group at a time when it was likely that the Ohio Supreme Court would accept the case, although importantly, it had not yet done so at that time. Again, her speech avoided any mention of pending cases or potential cases and focused instead on general constitutional and separation of powers matters. It did not discuss or refer to any cases pending before the court, nor did she mention abortion or the host group's positions at that meeting. However, she was nonetheless believed to be sympathetic to pro-life causes, as she had filled out a judicial candidate survey for Right to Life of Greater Cincinnati, in which she affirmed that she agreed with every position espoused by the anti-abortion organization, including its views on legal and constitutional interpretation. Nonetheless, no one even alleged that she had pre-committed herself to the particular issues in this case. And in addition, no party to the case actually filed a motion seeking her disqualification. Nonetheless, when she declined the call for recusal from outside groups, an attorney filed a grievance over her conduct. It was dismissed. A second complaint was filed, seeking an investigation by the Ohio Supreme Court's Office of Disciplinary Counsel. This time, Chief Justice Maureen O'Connor attempted to clarify the matter in a public statement, referring to the, quote, unfair criticism of Justice Kennedy, and explaining that all judges have a duty to speak to the public, and stating that neither the speech nor the justice's prior history of supporting proposed legislation or advocating for certain issues should disqualify her from hearing the case. But even this did little to stem the tide of public criticism. Two newspapers ran editorials calling on Justice Kennedy to recuse herself, concluding that her actions could allow a reasonable person to question her impartiality. A third newspaper's editorial board was divided, with one editor agreeing that because Justice Kennedy's speech did not touch on abortion issues, it should not be disqualifying. Others on the board were concerned that it at least gave rise to the appearance of partiality, and one went even further, stating that, quote, Justice Kennedy must face up to how recklessly ill-conceived is her view that such actions have no impact on the credibility of her rulings. The recusal dilemmas facing Judge Scheindlin and Justice Kennedy had certain similarities. In both cases, the judges were perceived, at least by some, to have certain political pre-commitments that could influence their rulings. In Judge Scheindlin's case, she intended her statement that she was skeptical of the police in general as a statement of open-mindedness. She contrasted her view to the views she imputed to some of her colleagues, whom she believed were inclined to favor the government. But the statement was taken by some instead as a statement of partiality, not of open-mindedness. In Justice Kennedy's case, critics interpreted her willingness to speak to a pro-life group and her endorsement by pro-life political groups as signs that she would be biased against an abortion provider in an upcoming case. Both cases were high-profile and very politically charged, and in both cases, partisan views on the merits diverged sharply. How could it be unreasonable, then, for an observer to believe that the judge's own partisan identity would threaten her impartiality? On the other hand, if that is true, then is it possible to find truly neutral judges? Or does it create a significant risk that all judges will instead be scrutinized under a partisan lens? And what does that do to the justice system, if so? My research looks at the foundations of partisan identity, looking to social psychology for an explanation of the processes by which people define their roles in society and in larger social groups. It then applies these processes to the question of political identity, examining how differences in partisan identity create wide gulfs in the political system and influence how observers are likely to view actions in the judicial sphere. Certainly in the last 20 years, there's no doubt that partisanship has grown stronger in America. The divide between the political parties is deeper and more strongly felt than it has been in many decades. In fact, research suggests that political parties may even be the most polarized they have been in the last 150 years, that is, since the Civil War. This polarization means that there is less and less common ground between the two major political parties. The percentage of people identifying with each of the two parties overall has actually not changed greatly over the years. The same number of people lean Democratic or lean Republican. But what has changed is how closely those people identify with their political parties and across how many dimensions, that is, their ideological consistency. In the past, it was more common for people to agree with some positions taken by one party and to agree with some positions taken by the other. In the last 2 decades, however, the percent of Americans holding consistently conservative or consistently liberal has doubled from 10% to 21% on each side. What this means is back in 1994 and 2004, you had a fairly normal distribution of political attitudes that centered around a median, with most people being somewhere in the middle. By 2017, that has flattened out a lot. There are many more supporters who are strongly ideologically consistent on one political side or the other, a much smaller middle. Studies examining Americans' attitudes towards members of the opposing political party have found that people hold negative personal characterizations of their political opponents, believing them to be more close-minded, immoral, lazy, dishonest, and less intelligent. 50 years ago, less than 5% of Americans of both parties said that they would be troubled by a son or a daughter marrying a person from the other party. By 2010, that share had jumped to half of Republicans and a third of Democrats would be troubled by a child marrying somebody of the other political persuasion. This very personal partisan divide does not just separate the electorate. It also divides elected officials. Voting by members of the House of Representatives has gotten significantly more polarized in the last 50 years, leading to a lack of cooperation between the two sides. Because the number of moderate representatives willing to work across party lines has diminished, it has become much harder for Congress to pass legislation, as there is much less opportunity for political give and take. And of course, these trends affect elected officials. Many judges are elected, but they also, very importantly, affect how individuals view the judiciary. When people come to view the world through this very polarized political lens, it changes how they view the judiciary. It changes how they view judicial decisions that could be perceived as political. And it changes their overall faith in the court system. So this growing political polarization creates real danger for the judicial branch. The appearance of impartiality is critically important to the effective functioning of the judiciary. But judges, of course, are not immune from the political pressures and partisan interests that pervade the political branches of government. And the public who watches judicial decisions is not immune from the growing polarization and growing distrust of those with different political views. So the judiciary really faces conflicting expectations from the public. On the one hand, the public relies on the judicial branch to safeguard the constitutional rights and liberties that are not always protected by the political branches of government. In order for the court system to play this role effectively, judges must maintain their impartiality. And indeed, even today, the public generally does believe in judicial impartiality, or at least in contrast to the political branches of government. And in large part, this belief is very well warranted. Scholars have noted that credible examples of judges deciding cases based on responsive or tribal partisanship are noted for their extreme rarity. But particularly in recent years, the public often has an additional hope for the judiciary, and that is that it will help move forward their desired policies. perhaps because the gridlock facing Congress in recent years has made it seem a less likely vehicle for political efforts. The future composition, especially of the United States Supreme Court, was described by people on both sides of the political aisle as the most important issue in the 2016 presidential election. As Professor Richard Hassan has stated, with gridlock in the political branches, the Supreme Court's word is often the final word on U.S. policy on questions from healthcare to voting rights. As the country has gotten more polarized, there has been more overt discussion of seeking to stack the bench with politically compatible judges. Republican senators refused even to grant a hearing to Merrick Garland after he was nominated to the Supreme Court by President Obama, in spite of the fact that Judge Garland has previously been uniformly praised on both sides of the political aisle. And in an inverse of President Roosevelt's court-packing plan, some, including one senator, had even suggested that the seat should remain open indefinitely if a Democratic president were elected in 2016. Of course, that didn't happen, but had Clinton been elected in 2016, there would have been a movement to leave that seat open indefinitely. After President Trump appointed Justice Gorsuch to the court, the Senate dropped its supermajority requirement for his confirmation vote, allowing the confirmation to proceed on a party line vote. Democrats, in turn, amped up the partisan rhetoric, decrying the stolen seat as if there had been a property interest in that seat. The public view of the judiciary is therefore somewhat conflicted. Although people generally see judges as impartial, they also say they want to see judges on the bench who share their political views. Somewhat counterintuitively, the public actually has greater faith in elected judges rather than in appointed ones. The partisan nature of most judicial elections is apparently not seen by the public as a threat to impartiality. Americans do believe that raising money compromises the integrity of the judiciary, but also believe that a judge who voices his opinions prior to taking the bench can be fair and impartial in a later case. On the other hand, when judges do demonstrate their impartiality by voting in a way that contradicts their political affiliation, their previous supporters sometimes will see that as a betrayal. So, for example, when Chief Justice Roberts voted to uphold the Affordable Care Act, and when Justice Anthony Kennedy ruled in favor of same-sex marriage, both of their rulings and their decision to join the majority angered many grassroots conservatives who saw those votes not just as political disagreement or judicial impartiality, but actually believed that those rulings breached the rule of law itself. Judges' own expectations for the judiciary in some ways mirrors the public's. The ideal of impartiality is a salient and perhaps the most salient aspect of the judicial identity. But at the same time, judges are human, and they're therefore susceptible to the same unconscious biases that affect us all. The more importance, interestingly, a judge places on impartiality, the more cognitive dissonance is caused when that impartiality is later questioned. Now, importantly, a judge who independently determines that he or she should recuse in a case is not likely to have a negative response to that, because such a decision does not conflict with his or her identity as someone who values impartiality. Indeed, that identity is only enhanced by the personal decision to recuse. That self-conception as a judge who values impartiality is enhanced when the judge voluntarily steps aside. On the other hand, however, receiving a motion seeking involuntary disqualification can feel like a threat to the judge's core judicial identity. Professor Charles Guy has explained how a motion to recuse can give rise to an emotional reaction from the judge. He writes that judges are well aware that the ethical rules require them to avoid even the appearance of partiality. And as a result, he says, being accused of looking bad when they don't think they looked bad creates a stress point for the judge. And he finds that judges are very reluctant to concede that they may appear partial when faced with a motion to disqualify. A judge's partisan connections makes such motions more likely, especially in this very polarized era. Partisan connections, of course, are replete in the judiciary. In a majority of states, judges run for election, typically on expressly partisan platforms. In fact, in some states, it is not uncommon for litigation to proceed from start to finish by state court judges of a single partisan persuasion who were elected in expressly partisan contests. Even in federal court, where judges are appointed for life, the influence of partisan politics is nonetheless unavoidable. Politics play a role in the composition of the federal courts, in the oversight of the courts, and in shaping the court's jurisdiction. Even the Supreme Court itself and its internal decision-making is not immune from the negative effects of political polarization. In a recent interview, Justice Elena Kagan explained that the court's approach to decision-making varies according to how controversial, how political the case is. The case is less likely to capture public attention, that's the civil procedure cases that I love so much, are actually easier for the court to deliberate and to discuss. And so they're subject to longer discussions at the court's conference. The court spends more time deliberating, discussing, coming to an agreement. That deliberative procedure is incredibly valuable for coming to a conclusion that comports with the law, that makes logical sense, that enhances the court's legitimacy overall. The more high-profile and politically significant cases, though, which are often decided, right, by a 5-4 vote, the high-profile cases, Justice Kagan said, that appear on the front page of the newspaper, those cases actually get less time in group deliberation, which seems counterintuitive. Why would this very important controversial case get less time in deliberation with the court? But Justice Kagan said that further discussion of those cases would just irritate colleagues and change no one's mind. So these cases that, controversial cases that reflect a very polarized point of view actually get less discussion, less deliberation from the court. So given the psychological forces that act on all of us, it would not be surprising for judges' political identities to result in unconscious biases that conflict with the judge's self-conception as impartial decision makers. The trouble is in trying to identify the particular occasions when such biases manifest themselves. How do we know when those biases are potentially acting on a judge or on a court? Cognitive biases by their nature operate at an unconscious level. People are not aware of them. We have what's called a bias blind spot, where people are generally unaware of their own cognitive biases. Political bias in particular is especially to pin down and especially hard to pin down in the judiciary, because at some level, politics, ideologies, theories of governance, and theories of interpretation actually shade into one another. Nonetheless, what we can say is that there are patterns of biased judicial decision-making in a number of contexts. Scholars have found that when judges are able to override jury decisions on the death penalty, this has been struck down now, but in the past when they were able to do so, elected judges were much more likely to grant the death penalty than appointed ones. And even for appointed judges, scholars have found that the probability that a capital verdict will be reversed on final federal review seems to be related to whether review is by judges mainly appointed by Republican presidents or by judges mainly appointed by Democratic presidents. Likewise, research has found that judicial decisions tend to ally with judges' retention incentives in states where judges have to run for retention. And this is true whether those judges were initially elected or appointed to their bench. Their rulings appear to behave roughly the same in terms of partisan favoritism that would cater to their party audience for those judges who are running in a retention election. Recent empirical work took that research even a step further, investigating whether a partisan bias could be found when examining judicial rulings in local election litigation. Not only did the researchers find such a connection, but they also found that that connection did not hold true for the lame duck incumbents who were vacating their seats. So judges tended to behave one way when they knew that they were facing a retention election, and rule differently when they were in a lame duck position and did not have to worry about keeping their seats. So the research suggested that judicial selection alone could not fully explain the relationship between campaign contributions and partisan loyalty in these cases, because it held true for judges facing retention elections, regardless of whether they were initially elected or initially appointed. So all of these contradicting principles come into play in responding to calls for disqualification in particular cases. The public largely believes that judges can remain impartial, and the public expects them to do so. But in politically sensitive cases, people also believe that impartiality means aligning with their own policy choices, right? If you agree with me, that means you're impartial. The concept of impartiality is a very strong part of the judicial identity, but that identity does not always shield judges from ruling in ways that favor their social, political, or economic interests. And in fact, that very strongly held belief in the importance of impartiality sometimes works counterintuitively, where the judge is less able to scrutinize their own motives. So the fact that impartiality is integrated so tightly into the judicial identity can actually make it harder in some cases for judges to recognize their own unconscious biases. So under these circumstances, how can the legal profession best protect judicial impartiality in this era of such entrenched partisanship? Well, the ABA's Model Code of Judicial Conduct, like Ohio's code that we looked at the beginning, provides that a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned. The code also gives a number of specific instances in which appearances require the judge's disqualification no matter what. So, for example, situations where the judge has a financial interest in the case, where the judge has made statements that appear to commit the judge to reach a particular result in future cases, or situations where the judge's spouse or child is acting as a lawyer for a party in the case. In these cases, we just apply a bright line rule and say the judge is automatically disqualified. It doesn't matter if the judge thinks that he or she could still rule impartially. These are situations that require a bright line rule for disqualification. The Model Code defines impartiality as the absence of bias or prejudice in favor of or against particular parties or classes of parties, as well as maintenance of an open mind in considering issues that may come before a judge. In spite of the breadth of this definition, which sounds like it could encompass almost anything, not all preconceptions are actually disqualifying. So the Supreme Court has interpreted the words bias and prejudice in this context to, quote, connote a favorable or unfavorable disposition or opinion that is somehow wrongful or inappropriate, either because it is undeserved or because it rests upon knowledge that the subject ought not to possess, or because it is excessive in degree. So just because judges are human and come to the bench with certain preconceptions, certain likes and dislikes, certain political beliefs, the Supreme Court has said that that itself is not disqualifying, that more is required. Judges are responsible for voluntarily stepping aside when they are disqualified under these provisions. Of course, litigants can also file motions seeking to disqualify a judge. In most jurisdictions, the challenged judge will hear and rule on the motions themselves, a practice that has been subject to much criticism, because nobody wants to hear that a party thinks that the judge is biased. For these motions, there's typically no formal opinion issued when a motion is denied, and approximately 90% of all disqualification motions are, in fact, denied. So a judge who determines that the grounds for disqualification have not been met should deny the motion and should hear the case. The federal courts and most state courts recognize a duty to sit when the judge is not, in fact, disqualified. So as a well-regarded treatise has summarized, quote, a federal judge still has a duty to sit unless there are grounds for recusal. A federal judge has never been permitted to recuse because a case would impose personal burdens or because he would rather handle some other kind of case. And the disqualification statute certainly does not provide such license. So it would actually be inappropriate for a judge to simply say, all right, somebody has accused me of appearing to be partial, so I am automatically going to step aside. In fact, the judge actually has to scrutinize that situation and has a duty to consider whether that allegation is in fact reasonable, whether a reasonable observer under the facts would in fact believe the judge to be partial. Appellate courts can review a judge's failure to step aside. In the last 10 years, the Supreme Court has twice held that a judge's failure to do so resulted in a violation of the litigant's due process rights. First, in Caperton versus A.T. Massey Coal Company, the court held that an elected judge whose campaign was funded in large part by a single donor, the CEO of a mining company, could not constitutionally adjudicate a case in which that company was a party. The court noted that a subjective belief in impartiality was, in fact, not enough. Instead, the court applied an objective test to determine whether recusal was necessary, finding, quote, a serious risk of actual bias based on objective and reasonable perceptions when a person with a personal stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending or imminent. Given the importance of this very large contribution to the judge's campaign, the court held that due process required recusal. More recently, the Supreme Court issued an opinion in Williams versus Pennsylvania, a case in which an elected district attorney sought the death penalty against a defendant, was then elected to the Pennsylvania Supreme Court many years later, decades later, and in that capacity voted with the court to deny habeas relief in a decades later proceeding filed by the same defendant. The court reversed the judgment of the Pennsylvania Supreme Court, holding that under the Due Process Clause, there's an impermissible risk of actual bias when a judge earlier had significant personal involvement as a prosecutor in a critical decision involving the defendant's case, even though it was many, many years ago. In determining that the risk of actual bias was unacceptably high, the court referenced the concept of unconscious bias. This was the first time that the Supreme Court had actually referenced research regarding unconscious bias in this context. And the court noted that there was a risk that the judge would be so psychologically wedded to his or her previous position as a prosecutor that the judge would consciously or unconsciously want to avoid the appearance of having erred or changed position. The court also emphasized the importance of the appearance as well as the actuality of impartial adjudication, saying, quote, an insistence on the appearance of neutrality is not some artificial attempt to mask imperfection in the judicial process, but it is rather an essential means of ensuring that reality of a fair adjudication. Both the appearance and reality of impartial justice are necessary to the public legitimacy of judicial pronouncements and thus to the rule of law itself. So given the broad standard of the judicial conduct rules, that is, disqualification is required whenever a judge's impartiality, quote, might reasonably be questioned, along with the Supreme Court's emphasis on the appearance of impartiality, it might seem that motions to disqualify judges based on political pre-commitments and partisan affiliation would be on strong ground. Indeed, commentators have called on parties to more often seek disqualification on these bases. But scholars have found that such disqualification motions are effective only when the sources of bias are objectively identifiable, and other judges who do not suffer from the same bias may be found. This is a hard standard to meet. So when the bias at issue is a political worldview or ideology, such objective identification may be difficult or impossible. As I mentioned, politics cannot be effectively separated from other underlying ideology, governance theories, or even legal interpretation. So for example, if you know that a judge views themselves as an originalist, right? They believe in originalist interpretation of the Constitution. Knowing that can allow an observer to make reasonable, although not perfect, predictions about how the judge might rule in constitutional cases. And on balance, such rulings are associated somewhat more with one political party than with the other. Likewise, knowing that a judge was appointed by a Republican or a Democratic president makes it somewhat easier, again, to predict the judge's rulings, although, again, with highly, highly imperfect accuracy. So hindsight bias, of course, can make such predictive accuracy appear stronger than it actually is when people think, of course, the judge ruled that way. They're a Democratic appointee, they're a Republican appointee. But there are enough examples of judges ruling contrary to expectations that no prediction can ever be guaranteed, even if in the aggregate we know that there are some correlations. And even when judges do, in fact, rule in accordance with their perceived political leanings, it does not mean that that judge is in any way beholden to party interests. Instead, such a ruling may simply reflect either the thoroughness of the vetting process prior to the judge's appointment. So the judge is appointed by a president who has thoroughly vetted the judge's views and has appointed somebody to the bench who is aligned with those views. Or it may, in some cases, reflect a high level of concordance between the judge's views and the views of a majority of the electorate who may have voted for that judge in an election. In either case, the judge's personal views, such as being perhaps skeptical of the police or holding religious objections to abortion, may well have figured into the judge's ascendance to the bench in the first places. In both cases, a reasonable observer may believe that the judge's view and political identity would cause her to unconsciously sympathize with certain parties. But in either case, there are no specific facts that would lead a reasonable observer to conclude that the judge could not set aside that sympathy and rule impartially. The Supreme Court, after all, has stated that disqualifying bias would likely either rest on the appearance of knowledge that the judge ought not to possess, or a sympathy that is excessive in degree, something more than the ordinary beliefs that all of us have and that judges take with them to the bench. Courts have furthermore held that the recusal statute should not be construed so broadly as to become presumptive or to require recusal based on unsubstantiated suggestions of personal bias or prejudice. So the question, of course, then, is how do you define the appearance of bias that is excessive in degree? What does that mean? What kind of evidence is necessary to substantiate it? Certainly the majority view from the courts appears to be that one's worldview and social identities do not indicate disqualifying bias. So courts have therefore held that an Episcopalian judge could hear a case in which an Episcopal diocese is a litigant. And in another case, a judge whose wife was litigation director for the ACLU could hear a same-sex marriage challenge even though the ACLU had filed amicus briefs in other same-sex marriage cases, but importantly, not the one pending before that judge. A judge who had sponsored death penalty legislation as a state legislator earlier in his career could oversee prosecutions brought under that law, and that would not be disqualifying. So as one legal scholar has noted, the recusal process is not particularly effective in cases of alleged partisan bias. The appearance of impartiality, after all, is in the eye of the reasonable beholder. And as the public grows more partisan day by day, views of judicial conduct will likely split along party lines. It becomes very difficult to identify a single reasonable beholder when the world is so polarized. So we see this very much in response to the two situations I set out at the beginning. To law and order conservatives, it seemed obvious that Judge Scheindlin's action gave rise to the appearance of partiality. To liberals, on the other hand, it appeared obvious that Ohio's Justice Kennedy did. But neither view was widely shared by those with the opposite political identity. Those on the more liberal end of the spectrum saw Judge Scheindlin as, in fact, upholding the ideals of impartiality. And those on the more conservative side of the spectrum certainly saw no issue with Justice Sharon Kennedy sitting on the case. So when the public is so polarized, it becomes incredibly difficult to identify the view of a so-called reasonable person. This is especially true, right, when members of both political parties are at this point very predisposed to see the other political party as being, in fact, unreasonable, right? And that goes back to all of the personal views held by people about other people in the opposing party. So at its worst, this process may actually be counterproductive. As some have worried, given the judicial norm of impartiality, an accusation of bias, if taken seriously, will weaken public respect for and undermine the legitimacy of the opinion. That people will actually lose faith in the judiciary if they are repeatedly faced with accusations of political bias relating to the judges. In a few situations, such as the Williams and Caperton cases I talked about, the facts may actually be so dramatic that it's not difficult to say that the appearance of bias is either suggestive of improper connections to the case, as in Williams, or of partiality based on extraordinary circumstances, as in Caperton. In those cases, disqualification is critically important, not just to protect the appearance of justice, but also to protect fundamental due process. But in the general case of unconscious partisan affiliation and bias, disqualification motions are unlikely to solve the problem. If we rely on them as the primary vehicle to address the possibility of partisan bias, then we run the risk that nearly half of the country will not just be disappointed in the disqualification ruling, whether it's granted or not, but will actually lose respect for the legitimacy of the court. So, if disqualification alone cannot solve the problem of perceived partisan bias in the judiciary, what else can be done? One possibility is to expand the use of bright-line recusal rules that do not require the exercise of discretion. The ABA Model Code of Judicial Conduct, for example, contains 14 situations in which the appearance of bias is presumed. So cases like I've mentioned, where a judge has a financial interest in the case, or where the judge's spouse or lawyer is a party. Additional grounds for non-discretionary disqualification, especially grounds tied to certain partisan activities, such as attending overtly partisan gatherings, could potentially be adopted, and some have recommended that they be adopted. But again, it remains really unclear whether such an expansion could work in our current system of partisan judicial elections. Another reform is to allow a single peremptory challenge of a judge similar to how peremptory challenges of jurors work, and that might avoid some problems. In fact, nearly half of the states, 18 states, now have some form of peremptory disqualification of judges, including large states such as Texas and California. And I think it would not be a bad idea for the remaining states and the federal system to consider adopting such a process. This procedure might be especially important in protecting against the appearance of partisan bias because it neither requires substantiation of bias, nor does it threaten the judge's self-conception of impartiality. And if both sides are given a single strike, so this is similar to how it works in Texas, right? Each side can have one strike at the trial court level to say, this is not the judge I want on the case. They don't have to give a reason for it. They don't have to prove any sort of appearance of bias or partiality. They have one shot. If both sides are given the single strike, then parties are going to have to choose very, very carefully. After all, every judge comes to the bench with his or her own worldview. So the parties have to think about, is this particular judge worth using the party's single strike on? Because both parties get a single strike and they don't know who would be replacing the judge, then chances are strong that the judge who hears the case will be perceived as, if not entirely unbiased, at least as legitimate by both parties. But perhaps I think the most important protection of an impartial judiciary is actually our procedural system itself. I teach civil procedure, so of course I love procedure. But I think that our litigation procedure actually provides remedies for the most egregious cases. The founders of our tripartite democracy realized that imperfect impartiality was an impossible goal. We can never expect perfect impartiality because people do come with their own worldviews. As long as judges are human, they're going to be subject to the same unconscious biases and blind spots that affect us all. What matters instead is that judges are impartial enough to fulfill the role assigned to them under state and federal constitutions, that is, to uphold the rule of law. Given this reality, the founders created procedural safeguards within the American judicial system to counter ordinary levels of partisan bias. For the founders, the most important mechanism to curb judicial bias was the jury. The anti-federalists, concerned that judges would naturally favor private citizens or organizations that were part of the ruling elite, believed that the civil jury would, quote, serve as a bulwark against private as well as public oppression. Alexander Hamilton likewise wrote that juries could provide a security against corruption. And although jurors as well as judges can suffer from bias, Hamilton believed that both judge and jury could provide a check on each other. Today, of course, the jury trial is used much more rarely than it was at the time of the founding. People have talked about the death of the jury trial, but I would say that the jury process, although endangered, is not yet dead. In addition to its adjudication role, the mere presence of a jury or possibility of a jury can serve a watchdog function, encouraging judges to consider a diversity of viewpoints. Lawyers, judges, and others who care about the functioning of the judicial system should work hard to ensure that juries continue to offer a check on judicial decision-making. And even though the jury may have declined in use, another procedural safeguard, that is a very robust appellate system, has become a fundamental cornerstone of the judicial system over the last century. Appellate review helps to minimize the effects of a single judge's bias. Appellate review, of course, does not guarantee bias correction, but evidence suggests that the old adage, more heads are better than one, does in fact hold some truth. Group decision-making tends, at least on average, to lead to less biased outcomes. Between the process of deliberation, the law of averages smoothing out the risk of individual bias, and the multiple points of view on a panel of judges, a multi-member court is less likely to give rise to a biased judgment. Focusing on appellate law as a bias correction mechanism also has a separate advantage. It ensures the standardization of legal doctrine, allowing that doctrine to be applied without regard to a single judge's predilections. So thus, while judicial discussions of personal bias can tend to polarize opinion and risk undermining judicial legitimacy, decisions of doctrine generally do not run the same risk. The removal of Judge Scheinlin from the stop and frisk case, for example, was highly controversial, with accusations of judicial bias on both sides. But the constitutional doctrine itself, while still very politically charged, did not lead to the same vitriol against members of the judiciary. Ultimately, the issue was settled, at least for the time being, by a combination of judicial involvement and political decision-making. After the policy of stop and frisk was ruled unconstitutional, a new political administration was elected in New York and chose to drop the appeal so that that ruling would stick. So to conclude, the perception of judicial impartiality is essential to a belief in judicial legitimacy. In the current era, unfortunately, the public's deepening political divide threatens the perception of judicial neutrality. Hardening partisan identities means that there is less middle ground on political issues and less cooperation among those with differing political views. As a result, the public increasingly scrutinizes judges and judicial candidates for signs of political agreement and, importantly, for signs of political opposition. That scrutiny often raises questions about judges' political commitments. Judges must generally have strong political affiliations to reach the bench at all, regardless of whether they are elected or appointed. And furthermore, in spite of a very strong judicial identity that demands impartiality, judges have the same unconscious biases and preconceptions as anyone else. So protecting the appearance of judicial impartiality can be a very difficult task. Disqualification motions can counter the most extreme cases of potential bias, as in Williamson or Caperton, but such motions work much less well when political views diverge. At the end of the day, our ordinary procedural tools, including the right to a jury trial and our system of appellate review, may better protect the integrity of the judicial system. Thank you. And thanks. And we are close to time, but I think we have a couple of minutes for questions if people would like to ask questions.
what if the judge? What if the party really doesn't like the judge? Why don't they just go and contribute $1 million to his campaign so that we can't? So that now we're a contributor. Now we won't have that. Has that played out?
Yeah. So it's hard to tell, but it's a huge concern. Very, very few people have the ability to donate $1 million every time they want a judge disqualified. But where it does come into play a lot is a number of states have adopted rules saying that some level of contribution should be presumptively disqualifying. And the really difficult part that they've struggled with is, where do we set that dollar value? If we set it at $1 million, we don't have to worry that people are going to abuse it, because people don't have largely the money to abuse it. Most cases aren't even worth that much. But states have talked about setting it around $5,000, and that becomes much more difficult because there are plenty of parties who do have $5,000 to try to contribute to do that. One thing that states have done is to say, well, it won't be disqualifying if you are making this contribution at a time when it's foreseeable that you will have a particular case in front of this judge, because we're just going to infer in that situation that you are trying to get them disqualified. That helps to some degree, but it lends itself to gamesmanship. Good, maybe one more?
So I'm a little troubled by I'm a little troubled by the legal standard itself, which is this idea that if a judge's impartiality could reasonably be questioned versus the actual application and the narrowness of the bright line rules. And to give you an example of this, and I'd like your reaction to this, to me, we were all taught that the idea of reasonableness is the lowest standard in the law, right? So if I can reasonably, it's like the rational basis test. If I can reasonably, cogently give you an argument, then that's it. I'm reasonable. Yep. And yet it seems that judges, in applying the rule, have made it more like strict scrutiny. And so an example of this, if you narrowly conceive of these bright line rules as things like a financial interest, well then say, for example, if someone is challenging the constitutionality of a statute, that doesn't necessarily have anything to do with a financial issue, but you challenge the constitutionality of a statute, and a judge who's hearing the case say their spouse was the person who adopted the statute into law, a normal person, a normal average citizen, could reasonably question whether they're going to get a fair shake in front of the judge, and yet we leave it to the whim and discretion of that judge to say, well, no, you're just not being reasonable. I have a duty to sit. I'm going to continue to sit. So I feel that what we need is, and this was one of your examples on solutions, is we need a lot more either bright line rules or actual vigorous enforcement of the reasonableness test for what it means in plain language, and not leave it to the whimsy of judges. I'd welcome your comment on that.
Yeah, so I think that's a difficult situation, and it's an interesting one, because the judge in that case does not have certainly no direct financial interest. The judge's interest would be somewhat akin to what the court recognized in Williamson, which is this unconsciously being wedded to something. In Williamson, right, they're worried that the judge was unconsciously wedded to their older position in the case as a prosecutor, that even 20 years later in a new case involving the same defendant, they would want to appear to be consistent with their earlier position, even if unconsciously, and that was too much of a conflict. Here we're kind of one step removed, because the judge might have an unconscious interest in wanting to make their spouse not look like they committed error by adopting the statute that's later
violated the Constitution.
Right. That's later found to have perhaps violated the Constitution. So in some senses, it's a line drawing problem. If we're worried that a judge might be too wedded to their own decision, do we share that same level of concern that the judge might be too wedded to their spouse's earlier decision? I think that is a tough call.
But the appearance isn't, right? See, that's the issue. Reasonably might be questioned by someone else, as opposed to you might actually be biased.
And the problem with the reasonably might be questioned by someone else is the by whom. If it's by anybody, just one reasonable person would find this improper, I think that's not enough. I think you need to say that the average person, right, the median person in this political world would find it to be problematic, would have to be the standard. And for political decisions, that's really difficult because we used to have, right, a large middle. When we had a normal distribution of political affiliation, you can look and say, okay, the reasonable person is around that median because that's where most people are. In 2017, in this polarized world, we don't have that large middle. When the political views are flat over that, how do we decide at which point in the spectrum somebody is reasonable? I don't have a good answer to that one, but it's a tough question. All right, thank you very much.